Welcome to the fourth video on the enforcement and validity of international arbitral awards. In this video we will focus on enforcement and state immunity. What are the main principles of enforcement and state immunity? This is the main question we will be addressing in this video. The question of state immunity is of course only relevant in practical terms if a party in a dispute seeks to enforce an arbitral award against a state. The first step to take when you want to start enforcement proceedings is to determine in which countries you want to enforce the arbitral award. In most cases, you should consider the location where the losing party has its assets. It's important to point out that before one initiates enforcement proceedings, one needs to make sure that the award has been recognized. Once recognition has been obtained, enforcement can be sought. The enforcement proceedings are entirely based on the domestic law of the state in which you seek enforcement. There is thus little we can say about the practicalities in this respect, since they differ substantially from one state to the other. However, one element common to enforcement proceedings against states is that the procedure is not always smooth. States often raise their immunity as a defense to avoid the performance of the obligation under arbitral awards. State immunity in fact covers two types of immunities. First, immunity from jurisdiction can be relevant. Immunity from jurisdiction implies that a state is immune from proceedings in foreign national courts because of the independent status and the principle of equality between states. As a result, states are immune from any legal proceedings before the courts of another state, and consequently no claim can be brought against them. It is, however, common practice in many states that if a state has signed an arbitration agreement and participated in arbitration proceedings, that the state is considered to have waived its immunity from jurisdiction in respect of the proceedings related to that arbitration. This is often implicit and derives from the principle of good faith. The principle, however, can also be explicitly included in the arbitration agreement or the institutional rules. Such provision, for instance, can be found in Article 1.3 of the newly adopted investment arbitration rules of the Singapore International Arbitration Center, which you can access in the additional reading. This implies that a state cannot invoke its immunity from jurisdiction to hinder recognition or enforcement of an arbitral award before the national courts of another state. Secondly, and perhaps most importantly, immunity from execution is highly relevant. State immunity from execution often is a barrier to the enforcement of arbitral awards. Immunity from execution is a rule of international law which implies that enforcement measures against a state cannot be carried out with regard to property belonging to that foreign state. In other words, one cannot seize or attach the property of a foreign state. Many states have incorporated this firmly established customary norm in their domestic laws. There is, however, one notable exception to this, which is accepted in many but definitely not all states. A difference is made indeed between property a state owns and uses for public or sovereign purposes, what is called acta iure imperii, and property owned and used for private purposes, acta iure gestionis. The former category includes, for instance, embassies, consulate, embassy bank accounts, ministerial buildings, military equipment and ships, and so on. The latter category may include, for example, a building that is rented to private parties. Several states accept that the latter category of property may nonetheless be subject to enforcement measures such as seizure or attachment. Such property, however, is in practice not always easy to find, especially in the territory of a state other than the state against which you seek enforcement. The implicit or explicit waiver of immunity from jurisdiction does not apply here. In fact, most institutional rules and some domestic laws contain provisions which explicitly confirm the continued validity of a state's immunity from execution, even if it participates in an arbitration. This is the case, for example, in the mentioned Article 1.3 of the investment arbitration rules of the Singapore International Arbitration Center. It is also mentioned in Article 55 of the ICSID Convention. A waiver of immunity from execution would only exist if the state has expressly consented to waiving such immunity, for instance in the arbitration agreement. It's needless to say that this almost never occurs in practice. In this video, you have learned which principles of state immunity are applicable to the enforcement stage of international arbitral awards. You have notably learned that while immunity from jurisdiction often does not pose any significant problems, immunity from execution may still function as a bar to effective and speedy enforcement of awards against states. In the next and final video, we will discuss how immunity works in practice in the UKOS case. In this case, both enforcement and setting aside proceedings are currently being pursued.